I'm Mike Buckworth from Buckworth Solicitors, and I'm going to talk about share purchase agreements. There are three ways that a founder can exit a business, at the sale side. The first one is really a sale of the shares. That's pretty much self-explanatory. The second one is a sale of the assets by the company. And obviously what's happening there is the company selling its assets, it's getting money in for those assets, and it's pushing that money out to the shareholders through their shares. And the final one, which is the one that every entrepreneur, I guess, is aiming for, is a listing. And obviously when you list on a stock exchange or a public market, you effectively are selling shares. So an SPA, a share purchase agreement, is the document that governs the share transfer. So the first thing it does is set out how the shares are going to be transferred and what the mechanism for that is going to be. The second thing is it sets out how payment is going to be paid to the seller, when it's going to be paid, how much, those sorts of things. And the third thing it does is sort of set out the way that the company is going to be run between exchange and completion. Quite often with share purchases, you'll find that there is a initial transfer of shares, or there's perhaps a signature of the agreements, and then the sort of main transfer of shares happens at a later date. From the buyer's perspective, they want to know that nothing untoward is going to happen to the company during that period of time before they have full ownership, and that's governed in the share purchase agreement. There are three sort of ways that a buyer is protected in an SPA. The first one is by the seller giving representations of warranties. A warranty is really a contractual promise, so it's saying that a certain statement is true at the point at which the agreement will be signed. A good example might be a statement that I, as the seller, own the shares. If that's untrue, that's a huge problem for the buyer. If I don't own the shares, I can't sell the shares, and therefore the buyer may have paid me a large sum of money for those shares and find he doesn't actually own them. In those circumstances, he will sue me for breach of warranty, and he would aim to get back any money that he's paid to me. The second point is an indemnity. An indemnity is really the mechanism by which the buyer can protect any exposure he's got. So if we take the breach of warranty example, and I've given indemnity, then effectively pound for pound, his losses he can recover directly from me. So he can recover not only the money that he's paid to me for the shares, but also his legal fees and any other fees that he's incurred as a result of that warranty being untrue. The third thing, you don't always see it, but is a guarantee. So quite often if you've got a personal seller selling, he will guarantee the obligations that he has under the shareholders agreement to the buyer. So again, if he's giving a warranty that he owns the title to the shares, it may be he gives a personal guarantee of that warranty as well. The first approach for transferring funds is actually just for them simply to be transferred up front on the transfer of the shares. That's fantastic for the seller. The second option is an earn-out, and what's really happening here is the buyer is saying, you have told me this is a fantastic company, it's got really great turnover, you therefore will be happy to take that money over a period of time, and probably stay involved in the business as well, so that that value that you as the seller bring to the business can be sort of transferred across to me. The third thing is really withholding the funds, so deferring consideration or possibly putting them in an escrow account pending some sort of future event. So the obvious example of that might be if you say that funds will be released after 6 months, so long as the warranties still remain correct. The great thing for the buyer is that he has immediate control of money, so that if the warranties turn out to be untrue, then he can just withdraw from those funds. A seller really wants to be able to get a clean break, so they want to be able to get their money and walk away without any further liability, and really to limit any liability they've got as much as possible. So there's really sort of three things that we would look at doing for a seller. The first is to limit the content of the warranties as much as possible. So that's really making sure the warranties they're giving are entirely factual and they're absolutely 100% sure that all of them are going to be correct. The second thing is to limit the circumstances where claims can be brought. So what you quite often see is you see parallel provisions. The first one says that claims can't be brought for sums less than a certain amount. So in other words, you don't want people bringing claims for sort of 10, 20 quid. The parallel to that is that there's a cap on the claim, so that claims can't be brought above a sort of, let's say, £1 million cap. So that caps the liability of the seller there. And the final thing really is to try to limit the time that claims can be brought for. As a statutory matter, normally the limitation period for claims tends to be about 6 years. We would be trying to limit that period as much as possible. So you're probably looking about 1 or 2 years, on a good day. With tax matters, it's just worth saying it's a little bit different. Tax matters tend to be left for the full 6 years, because obviously from the buyer's perspective, the revenue can investigate those for the full 6 years, and he doesn't want to be on the hook if something goes wrong. prior to setting up Buckworth Solicitors, I worked in a city for one of the big US firms for 8-9 years, and really what I did for almost all of that time was SBAs. So I've got a lot of experience and very sort of high technical skills when it comes to SBAs. The great thing about using Buckworth Solicitors is you get that combination of a startup-friendly firm who prioritise startups and are really there to make startups life easy, and also that very high level of technical expertise. And I think that's pretty unique in the legal marketplace. I think the other point is that our business model is very different to other law firms. Everything is fixed fee. We even on SPAs we're not charging by hourly rates. So we'll give you a quote up front, and that's the price you pay at the end. And I think that's great for people selling their businesses. It gives them certainty as to what it's going to cost them.